Next, we come to the punishment for the offense of rape. The first provision for punishment for a rape under section 375 is the first subsection of section 376. This subsection provides that a person who is found guilty of committing rape shall be punished with rigorous imprisonment which shall not be less than 10 years but which may extend to imprisonment for life along with fine. So the minimum sentence for a person guilty of rape is 10 years and the maximum is life imprisonment. The minimum punishment was increased from 7 to 10 years by the Criminal Law Amendment Act of 2018 with effect from 21st of April 2018. This provision will not apply to those cases which are specified in subsection 2 of section 376 because for those cases a different punishment has been provided. So now we will see which are those cases which are specified in subsection 2 and we'll also see what punishment is prescribed for such persons and in such circumstances. Subsection 2 of section 376 contains 14 clauses from A to N and in each of these clauses a different situation of rape, a different circumstance of rape is specified and the person who is responsible for committing rape in each of these situations is liable to a much higher punishment than what is prescribed under subsection 1 of section 376. Here is clause A which applies to a police officer. If a police officer commits rape within the limits of his police station or in the premises of any station house on a woman in his custody or in the custody of a subordinate police officer, then he becomes liable for punishment under 376(2). Under clause B, it's a public servant who commits rape on a woman in his custody or in custody of a subordinate public servant. Such public servant is also liable for a higher punishment. Clause C applies to a member of the armed forces who is deployed in an area by central or a state government. If such a member of the armed forces commits rape in the area in which he has been deployed, then he deserves a higher punishment under subsection 2. Clause D. Any person who is on the management or on the staff of a jail, remand home or other place of custody or of a women's or children's institution commits rape on any inmate of the jail or remand home or place or institution as specified above, then he will be liable to punishment under this subsection. A person on the management or on the staff of a hospital will also be liable to punishment under this subsection if he commits rape on a woman in that hospital. Under clause F, a relative, guardian or teacher of the woman or a person who is in a position of trust or authority towards the woman will be liable to a higher punishment if he commits rape on such woman. Under clause G, any person who commits rape during a communal or sectarian violence will be liable for a higher punishment. Under clause H, any person who commits rape on a woman who is pregnant and about whom he knows that she is pregnant will be liable to a higher punishment under subsection 2 of section 376. Clause I has been deleted by the Criminal Laws Amendment Act of 2018 with effect from 21st April 2018. Earlier, it covered the case of a person who committed rape on a woman when she is under 16 years of age. Now we have a separate provision dealing with such persons. Under Clause J, a person who commits rape on a woman incapable of giving consent is liable to be punished under subsection 2. Clause K concerns a person who is in a position of control or dominance over a woman. If he commits rape on such woman, then he is liable to a higher punishment. A person who commits rape on a woman suffering from mental or physical disability is also liable for a higher punishment under this subsection. A person who commits rape causing grievous bodily harm or maims or disfigures or endangers the life of a woman also deserves a higher punishment under 376(2). Lastly, a person who commits rape repeatedly on the same woman is also liable to a higher punishment. So these are the 14 clauses, one of which has been deleted. Now we will see what is the punishment prescribed for all these persons. The punishment is rigorous imprisonment, minimum 10 years and maximum life imprisonment. And life imprisonment here means imprisonment till the end of that person's natural life. Minimum is 10 years here, but the maximum is imprisonment till the end of natural life. This is what we call as punishment for aggravated rape cases. All those cases which have been described from clause A to clause N of 376(2) are also known as aggravated rape cases. Certain explanations are attached or appended to this subsection. Armed forces means naval, military and air forces and includes any member of armed forces constituted under any law, including paramilitary forces and auxiliary forces. Hospital means precincts of the hospital, premises of the hospital, and it will also include premises of any institution for reception and treatment of persons during convalescence or of persons requiring medical attention or rehabilitation. Police officers shall have the same meaning as assigned to the expression police under the Police Act of 1861. A women's or children's institution means an orphanage or a home for neglected women or children or a widow's home or any other institution established and maintained for reception and care of women or children. While we are in section 376(2), we can gainfully revisit the provisions of section 114A of the Evidence Act. That section raises a presumption of law regarding the consent of a woman when she is subjected to sexual intercourse. This presumption is applicable only when there is a question before the court whether consent of the woman was obtained in a prosecution for rape under clauses A to N of section 376(2). We have already seen that these are the 14 clauses of section 376(2), where the offense of rape is aggravated, where trial is on for such a rape and it is proved before the court that this person, the accused, had a sexual intercourse with the woman concerned, and the remaining question before the court is only this: whether this sexual intercourse was committed with the consent of the woman. Then if the woman states in her evidence before the court that she did not give the consent, that is sufficient and the court shall presume that she actually did not give the consent and the offense of rape shall stand established.